Good afternoon, ma'am. Today's topic for my presentation is S. Hareharan Singh versus S. Sajjan Singh and others. The citation of this case law is 1985 1 SCC 370. The case had three bench of three judges. The name of judges are as follows: number one, Sabyasachi Mukherjee; number two, S. Murtaza Faisal Ali; number three, A. Vardarajan. The advocates from the both the sides were from the appellant side Saloni J. Saroji and K.P. Bhandari, senior advocates. S.C. Patel and Dr. Ruxana Swamy advocates were with them. From the respondent side, G.S. Garewal, senior advocate, R.A. Gupta advocate was with him. Law involved in this case is Representation of People Act 1951. Brief facts of the case law. The appellant filed an election petition against the elected candidate, respondent 3, on the allegation of corrupt practices. The appellant contended that Section 123, Subclause 3 of the Representation of Peoples Act 1951 had been violated for three reasons, which are as follows. Number one, sponsorship of respondent 3 and distribution of election ticket to him for the assembly elections by the Akal Takht, which is the supreme religious authority of the Sikhs. Number two, issue of Hukumnama by the Jathedar of Akal Takht in order to get him vote in the assembly elections and were also approved by Akal Takht was obtained to give the decision a color of religious authority. Number three, appeal to the voters at election meetings by referring to the Hukumnama to the writing in Akali Times, exhorting them to vote for respondent 3 by appealing to the religious sentiments and warning them of the consequences. In doing so, the former Chief Minister of Punjab had also represented in election meeting that respondent 3 was a nominee of Akal Takht and respondent 3 himself also had made the statement. Issues involved before the High Court were: number one, whether section 123 subclause 3 of the Representation of People Act 1951 had been violated. Number two, validity of the election of respondent 3 in the Punjab Legislative Assembly. Arguments from the appellant counsel were: the documents shown at the meeting were hukumnamas, and having regard to the background, it cannot be said that it did not have the effect of hukumnama on the community at a large of inducing them to believe that the claim of the candidate nominated by Shri Akal Takht and represented to be supported by Hukumnama would be an act of sacrilegious on the part of good Sikh. Number two, respondent 3 being a Sikh and a member of Akali Dal and having known the conditions precedent which were required to be filled before a proper hukumnama could be issued had not chosen to raise his contentions in his written statement. It was also urged that the concept of secular democracy is the basis of the Indian Constitution and the paramount and basic purpose underlying Section 123 subclause 3 of the Act is the concept of secular democracy. Section 123 subclause 3 was enacted to eliminate from the electoral process appeals to diversify such factors such as religion, caste, etc., which give vent to irrational passion. It is a powerful emotion that generated by election which should not be permitted to be exhibited during the election, and the decision of the people should not be colored in any way. Arguments of the defendant counsel were as follows. Number one, in order to constitute a hukumnama proper, there were certain conditions precedent which were required to be fulfilled. Namely, there should be a meeting of Sarbat Khalsa, that is, a meeting of all the Sikhs. Secondly, an anonymous decision must be arrived at, which should be followed by the approval of Shrimoni Gurdwara Prabandhak Committee, and the decision should be announced from Shri Akal Takht, and that in the instant case no such hukumnama has been issued. Number two, the constituency was mixed, equally divided into Hindu votes and Sikh votes. So, appealing to the Sikh religion in the such a case should be unlikely. Number three, the Akali party was in alliance with CPIM, and it was most improbable that when one of the aligned parties was Marxist Party, a candidate of Akali Dal would appeal in the name of the religion. The decision of the court was that respondent 3 was guilty of the corrupt practices under section 123 subclause 3 of RP Act 1951. Whether a Hukumnama, as alleged by the appellant, was issued or not should not be the main concern of the court. The court should see the case at a broader perspective. Sri Akal Takht enjoys a unique position amongst the Sikh, and any communication from Sri Akal Takht which is represented by eminent members of Sikh community as Hukumnama would have a great religious value, even though strictly speaking it might or might not be a Hukumnama. It was alleged that the former chief minister represented it so to be, and it was also represented by the candidate himself. And having the regard to the background, it cannot be said that it did not have the effect of hukumnama on the community at large, of inducing them to be believing that ignoring the claim of a candidate nominated by Sri Akal Takht and represented to be supported by hukumnama would be an act of sacral on the part of a good Sikh. Taking an account into the evidence and the communications of Akal Takht, it is clear that appeal in the name of religion was made on behalf of respondent through, though some facts stating in the oral evidence about meetings had not been stated in the petition, but when evidence were tendered and were not shaken in cross-examination, and the versions have a ring of truth in the background of other facts, the case of appeal to religion by respondent 3 has been proved in this case. This conclusion becomes irresistible in view of absence of any express denial by the former chief minister and in the absence of any explanation for not calling him on the as a witness in the present case. So the respondent number 3 has been held guilty. Majority opinion of the judges, the appellant and the respondent contested the election of Punjab Legislative Assembly held in May 1980 from SAR constituency. Polling was held on 31st May 1980 and the result was declared on 1st June 1980, in which appellant secured 29,600 votes and respondent number 3 secured 30,003 votes. The other candidates got only nominal votes. There was thus a difference of 403 votes in favor of the respondent number 3. Respondent number 3 was declared elected. The election of respondent number 3 was challenged by the election petition, alleging that the respondent number 3 had indulged in corrupt practices in the said election, and such his election was liable to be set aside and he was liable to be disqualified for the corrupt practices. Principles that were laid down in the case were as follows. The paramount and basic purpose underlying Section 123, Subclause 3 of the Act is the concept of secular democracy. Section 123, Subclause 3 was enacted so as to eliminate from the electoral process appeals of dividing factors such as religion, caste, etc., which give vent to irrational possession. It is essential that powerful emotions generated by religion should not be exhibited during election which color the choices of the people during the election of the candidates. Their lordships further laid it down. It would not be an appeal to religion if a candidate is putting up by saying vote for him because he is a good Sikh or he is a good Christian or he is a good Muslim, but it would be an appeal to the religion if it is publicized that not to vote for him would be against Sikh religion and against Christian religion or against Hindu religion, or to vote for the other candidate would be an act against a particular religion. It is the total effect of such an appeal that has not to be borne in the mind in deciding whether there was an appeal to religion as such or not. Conclusion of the case is as follows. Election process is the strength of the democracy, and including religion in this process is not acceptable, as we are a secular country and we cannot give vent to the irrational passion on the name of specific religion or caste. It's high time that we choose leaders on the basis of their capabilities to work for the betterment of the public, not on the basis of which religion or caste they belong. We are responsible citizens of the country need to understand that emotions which are attached to the particular religion should not be allowed to be exploited by the leaders while campaigning for the elections, because If by any means the decision and choice of the people are colored in any way, then the credibility of the democracy's biggest festival, that is elections, will decrease, and we will only become an electoral democracy, not a full-fledged democracy. Thank you, ma'am.